All right, well, hey, we're here for another try at another video. Frankly, I just did one and it wasn't any good, so I got a little help from my capable assistant, and I think it's working better now. So what we're here to talk about today is the Chapter 6 and 7 in business organization. So here you see it, and basically what we want to talk about is some things that can happen to an LLC if they fail to keep up their record keeping. There is a report that's due that you need to mail to the state. Usually, in some cases, I don't know if they still do this or not, but they used to be kind enough to send you a form to fill out. And all you had to do is take a pen and fill it out and say, you know, has anything changed? Is there a new president? Is there a new address? Is there a new phone number? It's just a single sheet of paper. You know, are your records up to date? Yes, no. Who are you? Are you the secretary? Yes. And usually they have like 2 officers sign it and mail it back. And that's usually the worst part of it, is getting 2 officers to stand still long enough to fill out the form and sign it. So if you fail to do this, if you fail to fill this form out and mail it in, then you get what's called administrative dissolution, which is really kind of a temporary suspension. Doesn't stay on the record if you turn right around and turn that in. So you'll get a warning letter saying you're basically going to be dissolved, and if you turn right around and send that in, then you're basically reinstated. So the issue there is you don't want to let that lapse completely, because eventually then you're going to be permanently dissolved, and you don't want that. So the other thing is a dissociation. You read about that in some places. Dissociation is a violation of the terms of the LLC contract or written agreement, and you're not allowed to dissociate without some kind of a new agreement where everybody agrees that they're going to buy you out, or they're going to take control of your interest, and it has to be a new written agreement to replace the old written agreement. If you don't come to an agreement and you just say, I quit, I'm gone, I leave, wrongful dissociation. Cannot do that. Third thing I want to kind of summarize and review a little bit is the 2 types of business entities that kind of make up this hybrid called an LLC. Limited liability company consists of parts of a partnership. The simplicity, it can be really small, just a couple members. And then at the same time, the legal protections of a corporation. And that's why it is being much more preferred over what we've studied earlier called the LLP. More and more I think that the LLP is a passing fad. So that LLC continues to be very popular. Well, hey, moving on to the Chapter 7 questions that we want to cover this week. What we're looking at here is that the regular or standard form of business corporation, it's been around for centuries, and the S corporation is not a standard or regular form of corporation. S corporation is a hybrid form created by the legislature in order to qualify for treatment by the IRS as kind of a pass-through corporation. So in other words, for tax purposes, it is like a partnership. 2 basic important documents that govern a corporation are the Articles of Incorporation and the bylaws. The original articles are set out by the parties, got to be signed by at least a couple people, mailed in to the state. You can actually walk down there now and they'll give you a form to fill out, and you can fill it out in ink pen right there on the spot, and then what they end up doing is they scan it into a memory. And so it may not look very pretty, but you can just go down there. As long as you got the money, the state's going to accept it. The problem that you can get into, though, is if you don't keep up on your paperwork by preparing bylaws, getting them signed, then filing your annual reports that are required, you could still lose your corporation as easy as they've made it to form one. So it's important that if you go down there and form a corporation, that you still need to follow basically all the niceties. And that's where it's really an advantage to have a lawyer go over it. It's not that much money, and the whole scheme of things. And, you know, they make sure that everything is favorable to the parties and, you know, that will pass legal muster. Because just because the Secretary of State accepts it, it doesn't mean that the courts are going to be happy with it. The Model Act is an act whereby members of a group of states came together and tried to develop a Model Business Corporation Act. The point of it is that a lot of these companies now, Chick-fil-A, McDonald's, Burger King, you know, they operate in all different states. They have franchisee. Once you operate in a state, then basically it's to your best interest to domesticate yourself in that state. There's forms that need to be filed. Now, if they had this Model Business Corporation Act, a lot of that can be streamlined and avoided a lot of extra paperwork. Question 5 is an issue about professionals. Doctors and lawyers now can form corporations. For many years that was not true. They could only be in a partnership because a corporation cannot be a lawyer. But there are ways that you can actually exist as a corporation as long as at least one member of the corporation is licensed to practice law. Same way with doctors. You can have all kind of different people involved in this corporation. You can have physician's assistants, nurse practitioners, but there has to be a doctor involved in this corporation. So basically those are the main things I want to cover. If you have any problems or questions, you always feel free to get a hold of me. I'll be there to answer your questions and let me know as we go along here. We're getting toward the middle of the course, so you need to be thinking about that midterm test. It is open book and it is based upon your questions. But let me know again if you need my help for any reason. Thanks a lot. Hope you have a good day.